Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Happy Monday before the A.P.A conference. I wish I could join you all, but alas, I cannot. Everyone enjoy Chicago. That's an order. Because of my FOMO, I interviewed outgoing A.P.A President Farshad Oji and incoming A.P.A President Kelly Stump this week. I'll get that episode out as soon as I can, but well, not yet. Also this week, President Biden appears to have shut down the southern border largely through executive order. Specifically, the White House website states that these are temporary, quote, new actions that will bar migrants who cross our southern border unlawfully from receiving asylum, end quote. Didn't know you could do that in non-emergency times, particularly through executive order and given our statutes and treaty obligations. Let's see how the already threatened ACLU lawsuit plays out. 4 cases again this week, although I'm starting out with some housekeeping, so does that make it 5? 6? 7? Who knows? Not I. Enjoy your week, everyone. Starting off with some housekeeping. Want to summarily get through 3 cases that piqued my interest this week that are immigration adjacent, but that I didn't feel it necessary to get too deep into. First this week, in United States v. Canada, of all cases, the Fourth Circuit succinctly held in the Armed Career Criminal Act context, based on an answer from the South Carolina Supreme Court itself, that due to the U.S. Supreme Court's decision in Borden, domestic violence in violation of South Carolina law is not a violent felony. That almost surely makes it not an immigration crime of violence, which means it also wouldn't be a crime of domestic violence for immigration purposes. As the Fourth Circuit recognizes, that means that it has vacated its prior precedent on this exact South Carolina statute. Moving on Friday, the D.C. Circuit held in the case Afghan and Iraqi Allies et al. V. Blinken et al. That the U.S. government remained bound in part by a lower court injunction issued in June of 2020 requiring various government agencies to abide by specific timelines for adjudicating special visa applications for Afghan and Iraqi nationals that had been pending for a long time. This despite the obvious surge in such visas after the fall of Kabul in the summer of 2021. It's because these visas are important, and after all, as authorized by Congress, are designed to confer immigration benefits on Iraqi and Afghan nationals, quote, who have worked for the United States government on the International Security Assistance Force for at least 1 year, provided faithful and valuable service, and experienced an ongoing serious threat as a result, end quote. Benefits for their immediate family, too. And who can possibly disagree with that? Pretty dang important. So the U.S. government must continue to adjudicate at least some of these applications pretty quickly. No beef with any of that, of course. But I must note, while it is a different statutory and regulatory framework, contrast that with the I-601A delay case that you'll hear from the 7th Circuit later on in this episode. Finally, Ira wanted me to mention Jajati v. CBP et al. From the 9th Circuit, published on May 22, 2024, a case that admittingly I had passed on when it was first issued. But of course, Ira's always right. It's an important case for challenging agency action under the Administrative Procedures Act, and succeeding at that. After all, the 9th Circuit in that case reversed the district court's grant of a motion to dismiss for lack of jurisdiction in an A.P.A. case brought against CBP for revoking Mr. Jajati's inclusion in the Sentry program, a trusted traveler program specific to the U.S.-Mexico border. Such claims, that is, getting your Sentry revoked, or trusted traveler, I suppose, can be reviewed, explained the 9th Circuit majority. Important claims for both suing CPP and for A.P.A. cases generally. By the way, if you're interested, it seems like the factual basis for him getting removed from the Sentry program might have been that his ex-wife was arrested for smuggling in methamphetamine and then she absconded. But I mean, ex-wife, right? Anyway, now he gets to get his case heard, and possibly his Sentry back. And that is some Caselaw housekeeping. Our first case is Smith v. Garland, published by the 9th Circuit on June 3, 2024. This case is about the government's waiver of argument and Convention Against Torture protection. As with so many cases of late, Mr. Smith entered the United States as a child and as a lawful permanent resident in 1982. But many years later, decades later, he was convicted of federal possession with intent to distribute methamphetamine. And that's gotta be a categorical match to a drug trafficking aggravated felony and a removable controlled substance offense, right? Because it is, after all, a federal conviction, and therefore must include the federal definition of meth and trafficking. I would think. Mr. Smith denied his removability, however, putting the government to its burden to establish his removability. DHS received a continuance to submit documents to meet its burden by clear, unequivocal, and convincing evidence as the law requires. To meet its burden to not only establish Mr. Smith's alienage but removability, DHS then submitted 1. A search result printout from a USCIS database. That was for alienage. 2. An FBI rap sheet to prove alienage in Mr. Smith's prior felony conviction. 3. A judgment downloaded from PACER to establish Mr. Smith's 2018 conviction. And 4. A Form I-213, memorializing an immigration officer's interview of Mr. Smith, proffered to prove Mr. Smith's alienage and prior conviction. No live testimony was provided to meet DHS's burden or to authenticate these documents, although an immigration officer did sign at least one of the documents and swear that it was true and correct. Mr. Smith's counsel objected to all of it, arguing that under 8 C.F.R. section 287.6, the documents were unauthenticated, and that in any event the documents were unreliable due to obvious errors in some of them. The immigration judge didn't quite address all the objections, but considered DHS's evidence and found Mr. Smith removable. Mr. Smith then applied for cat protection, which, among other things, required that he admit that he was from Guyana. A different IJ then overruled many of counsel's renewed objections and denied cat deferral, the only thing Mr. Smith was likely potentially eligible for due to his drug trafficking aggravated felony and matter of YL. The BIA affirmed, and the 9th Circuit affirmed that. Much of it is about those objections and authentication. Indeed, despite the federal rules of evidence not applying in immigration proceedings, quote, there is no question that authentication of documents is required in immigration proceedings, end quote. An IJ cannot simply do what Oil argued that the IJ and the BIA could do here, ignore authentication, simply believing that admission of the evidence in general was, quote, fundamentally fair, end quote. Whether a document should be admitted because it is fundamentally fair to do so is only a proper consideration for an IJ to engage in, quote, once a document is authenticated, end quote, explained the 9th Circuit. It seems that it's not actually in dispute that 3 of the 4 documents that DHS proffered were not authenticated at all. And not only that, of course, we have 8 C.F.R. section 287.6. That regulation applies to authentication of foreign documents and domestic documents. And it appears that the provision for foreign documents is a bit more permissive. That is, authentication isn't always required, which, to be honest, is kind of a benefit to non-citizens who often are relying on foreign documents. But for domestic documents, the specific regulation is section 287.6a. And the wording of that regulation was, quote, changed from may to shall, end quote, in 1985. Seems then that it's mandatory compliance for domestic documents. They must be authenticated. That is, under the regulation, authentication, quote, by an official publication thereof, or by a copy attested by the official having legal custody of the record, or by an authorized deputy, end quote, for domestic records, like the criminal records and documents like an I-213, used to prove alienage here. Now, the Ninth Circuit has been holding for years that strict compliance with the regulation for domestic documents isn't actually necessary, but explained this panel, it's done so by relying on pre-1985 precedent that doesn't account for the change of regulation language, that is, from may to shall. Backed into this corner, Oyl argued that the change from may to shall might have been a mistake in 1985. Not a great argument, but also, it's one that's held by some scholars, apparently. So Mr. Smith is totally right. But nevertheless, the Ninth Circuit punted, seemingly not comfortable overturning old precedent, even if it seems wrong now. Instead, the Ninth Circuit majority affirmed the BIA for a couple of reasons, including that Mr. Smith apparently did not object to a final piece of evidence, the authenticity of the judgment of conviction, until at least the petition for review stage, meaning that to the Ninth Circuit, Mr. Smith hadn't exhausted that argument. Then again, though, it seems like Oyl didn't make certain arguments either, at least until oral argument before the Ninth Circuit. Nevertheless, the Ninth Circuit decided to consider those arguments, which regarded about what Mr. Smith had himself failed to exhaust. Quote, because the merits of the government's forfeiture argument turn on the fixed transcript before us. The question of forfeiture is a narrow one involving settled law, and both parties addressed forfeiture at oral argument, end quote. So friends, if the opposite ever happens in your petition for review, that is, you failed to make certain arguments below or even in your briefs, but then you made them at oral argument, here are some things to try to get your arguments into the Ninth Circuit anyway. Oyl was allowed to do so, after all. Additionally, the Ninth Circuit held that Mr. Smith did not exhaust his challenge to the I-213, which was clearly not authenticated. But remember and cite to this decision to challenge I-213s, everyone. Seems like the Ninth Circuit is saying they need to be authenticated within the meaning of 8 C.F.R. section 287.6a. Nevertheless, explained the Ninth Circuit, Mr. Smith didn't allege that the I-213 was unauthenticated until the petition for review. Before that, he had been arguing that it was unreliable and inaccurate. Different arguments, and so unexhausted, said the majority. Similar with the FBI rap sheet, but again, the Ninth Circuit seems to agree that the rap sheet wasn't actually authenticated and that it must be so rely on this decision to make those arguments next time, too. Assuming then that authentication wasn't at issue, I suppose, the Ninth Circuit agreed that it wasn't fundamentally unfair to admit the documents and rely on them. Errors in documents often go to their weight rather than admissibility anyway. Turning then to cat protection, and just to summarize, quote, the IJ correctly concluded that this standard had not been met for one of Mr. Smith's theories of future torture, being denied access to psychiatric medication, becoming suicidal, calling a government suicide hotline, getting arrested, and being tortured in prison. The IJ separately analyzed Mr. Smith's other risks of torture before aggregating the risks from all sources, end quote. That was proper, and it was affirmed. Meaning Mr. Smith did not succeed. Here's some stuff from Judge Johnstone's dissent. Judge Johnstone, a recent Ninth Circuit appointee, agreed with all of that regulation stuff because it, quote, serves as a helpful prologue for a future case, end quote. Remember that. And believes that actually the problem originates way back in 1962. However, Judge Johnstone dissented, because he didn't believe that Mr. Smith had failed to exhaust his challenge to the only evidence that established his alienage in this case, even if he, quote, confusingly combined his authenticity and reliability objections, end quote, below. In any event, Judge Johnstone would be equally harsh to the government, which apparently did not argue that Mr. Smith had failed to exhaust certain arguments until oral argument before the Ninth Circuit. Judge Johnstone concludes by citing the Supreme Court precedent and noting that, quote, authentication is a foundational, if technical, rule of evidence, end quote. And that is Smith v. Garland. Next, we have Smith v. Garland et al., published by the Seventh Circuit on June 3, 2024. It's another Smith case, and this case actually arises in district court and touches on a lot of immigration issues. Miss Smith is from Mexico and was married to a man from Mexico named Francisco from 1973 to 2001. They had a son together. Just after their divorce, apparently, the couple tried to enter the United States, presenting themselves as married. They likely had tourist visas, the decision isn't quite clear, but CBP allowed them to withdraw their applications for admission at the Atlanta airport. 2 years later, they applied for non-immigrant visas again at the U.S. consulate in Mexico City, presenting as a married couple. But again, they were divorced by this point. They got visas, and in the United States, Francisco eventually married a U.S. citizen, who filed a Form I-130 petition on his behalf. USCIS denied it, though, noting that actually it appeared that Miss Smith and Francisco were living together. Francisco essentially admitted as much in a later petition filed years later, apparently. Meanwhile, Miss Smith married a U.S. citizen. Well, actually in 2012, after a lot of the Francisco stuff had already concluded. 5 years later, Miss Smith's new husband filed a Form I-130 petition for her. They waited a long time. And it seems like there was a lot of evidence of the validity of this marriage, but while that I-130 was pending, the new husband passed away, meaning that to the Seventh Circuit, citing the regulations, the quote, I-130 petition automatically converted to an I-360 petition, end quote, the form that's for many things, including widow petitions. Indeed, it is the case that immediate relatives can benefit from a pending I-130 if eventually approved, although they might have issues with the I-64 sponsorship requirement later, if I'm not mistaken. But we never even got there here, because USCIS denied the now converted I-360 petition. USCIS believed that Miss Smith had continued a close relationship with Francisco all these years, and that there was a history of the couple misrepresenting their marital status to immigration officers. Nor am I even at least quite clear on the exact timeline of when the couple was living together and when they stopped, at least based on how it was all relayed in this decision. Ms. Smith appealed the I-360 denial to the BIA, which affirmed USCIS, and then filed an Administrative Procedures Act lawsuit in federal court. A district court dismissed that lawsuit, although not on jurisdictional grounds. The district court judge didn't believe Ms. Smith could even state a claim, it appears, and the Seventh Circuit affirmed that. An A.P.A. action like this, of course, argues that the administrative agency, here USCIS and maybe the BIA, acted arbitrary and capricious in their I-360 denial. To the Seventh Circuit, that, quote, standard requires an agency to do its homework. Decisions that overlook relevant record evidence or lack a satisfactory answer do not pass muster, end quote. Alongside that, however, is the non-citizen or petitioner's burden before the immigration agencies when it comes to I-130s, I-360s, and other visa petitions. Quote, the petitioner bears the burden of establishing eligibility for the benefit sought by a preponderance of the evidence, end quote. Even only at the motion to dismiss stage, it seems the Seventh Circuit didn't see a case here. Pretty rough. First, it appears that the court is holding that Ms. Smith didn't even state a claim to possible relief when she alleged that the BIA ignored evidence by failing to discuss 8 pieces of evidence. Evidence that I'm sure Ms. Smith believes showed that she had a valid marriage to her second husband. The BIA need not discuss all evidence, even when, as here, it's reviewing USCIS's decision de novo. And USCIS apparently itself did discuss much of the evidence, if not all of it. Nor was it error not to discuss, to the Seventh Circuit at least, the statements submitted that apparently supported a valid marriage, given the credibility issues and past misrepresentations that appear to have occurred in this case. I wonder if those submitted statements were sworn affidavits, though. This decision doesn't say. But in any event, the Seventh Circuit saw this more as an argument to reweigh evidence that had been before the agency, which it doesn't do in these type of cases. Ms. Smith's other factual challenges fell for similar reasons. Now, Ms. Smith also argued that USCIS, and I suppose the BIA, failed to comply with the regulation at 8 C.F.R. section 103.2, B, 16I, and II, quote, by providing her with only a summary as opposed to the full documentation of the adverse information on which it based its denial of her I-360 petition, end quote. That is, Ms. Smith was challenging that the notice of intent to deny issued before the actual denial in which she could respond to wasn't specific enough and didn't actually contain the evidence that USCIS ultimately relied upon. And true, those regulations require that USCIS, quote, advise the petitioner of this fact and offer an opportunity to rebut the information and present information in his or her own behalf before the decision is rendered, end quote. When USCIS, of course, intends to deny a visa petition. That's why we get all these noids. USCIS's ultimate decision must be based on evidence that's actually in the record. Ms. Smith wanted that evidence, I guess, to confirm that the evidence is actually in the record. And how could she know, if not provided that evidence? Well, explained the Seventh Circuit. All that regulation stuff doesn't mean that USCIS must actually give the non-citizen or visa petitioner all of the evidence in the record that it's relying on. A summary will do. But like assuming no national security issues, why not? Why not require that the agency provide the evidence it's relying on? Why isn't that best practices? Surely sometimes there'd be a reasonable and persuasive explanation that USCIS hadn't considered and wouldn't have an opportunity to consider, but for providing the non-citizen the evidence, no? A promulgated regulation for another day, I suppose, because the Seventh Circuit doesn't believe that the current regulations require such action. The panel believes that the Seventh Circuit has actually already said as much through precedential decisions. All of this despite the fact that it seems Ms. Smith also tried to get at this information and the documents through a Freedom of Information Act request, but was denied the opportunity there, too. Nor did the Seventh Circuit see a plausible Fifth Amendment due process violation. Not even a claim stated at this, the motion to dismiss, stage. The Seventh Circuit believes that Ms. Smith got all the process she was due through the NOID and the opportunity to respond. And I guess through that BIA appeal as well. Finally, the Seventh Circuit rejected Ms. Smith's substantive due process right, asserted as the right of a U.S. citizen residing in the U.S. to reside with their non-citizen spouse. Taking us back to con law, quote, a substantive due process claim may proceed where the plaintiff asserts a deprivation of a right that is so rooted in the traditions and conscience of our people as to be ranked fundamental, end quote. A dwindling class of rights these days. Putting aside the fact that Ms. Smith's spouse had passed away, something not addressed by the court here, quote, the Supreme Court has not recognized this interest as fundamental, end quote. That is, a right to live in the United States with your U.S. citizen spouse. But who knows? The Supreme Court might decide that this month in Munoz. Hope springs eternal. Ms. Smith's federal court challenge to the denial of her I-360 petition, therefore, remained dismissed. And that is Smith v. Garland et al. Sticking with the Seventh Circuit, why not? We have Soni v. Jaddou, published by the 7th on June 6, 2024. This is, ironically, a short one about I-601 waiver delay cases. Mr. Soni is from Canada. He's been in the United States for over 1 year and surely entered unlawfully and is married to a United States citizen. He therefore can't adjust to lawful permanent resident status in the United States, and so he needs to consular process abroad to get his immigrant visa and then a green card after he re-enters. But the second he leaves the United States, he'll be barred from re-entering for 10 years under INA Section 212A9B. Fortunately, there's a waiver for that, and thanks to the Obama administration, he can apply for it in the United States before he leaves, and only if and when approved, then choose to leave the U.S. for his immigrant visa interview. He can do so relatively sure that he'll be let back in because he's now got the waiver. Of course, that assumes he gets the waiver, and of course he might end up like Mr. Munoz, stuck, possibly forever abroad, despite receiving the I-601A waiver and sitting for his interview abroad. We'll see what happens with Mr. Munoz in the coming weeks at the Supreme Court. Today is not that day. But hey, at least Mr. Munoz got his I-601A waiver approved. Showing extreme hardship to a qualifying relative is no easy thing, and children don't qualify as qualifying relatives for I-601A purposes. Better have a U.S. citizen or lawful permanent resident parent or spouse. But more material to this case, USCIS is now crazy delayed adjudicating I-601A applications. Mr. Soni sued USCIS, surely a mandamus or A.P.A. action, after his I-601A had remained pending for 17 months, but the district court dismissed his complaint for lack of jurisdiction. After all, reasoned the district court, the last sentence of the waiver statute at INA section 212A9B-V states that, quote, no court shall have jurisdiction to review a decision or action by the Attorney General regarding a waiver under this clause, end quote. But that's not what's happening, silly district court. Mr. Soni isn't challenging USCIS's decision or action. He wants a decision and action. The Seventh Circuit disagreed with me. The Seventh Circuit reads the word action quite broadly to literally mean the opposite of action, to include inaction. Or that is to say, quote, setting priorities, for example, how many employees to assign to processing applications under this clause as opposed to handling other duties is an action regarding waivers, end quote. Indeed, in a quote that seems designed to try to delay federal court actions, the Seventh Circuit reasons that, quote, allocating more personnel to dig into matters faster for one class of non-citizens would mean delayed decisions for others. The judicial branch lacks authority to direct Congress to increase the agency's budget and hire a larger staff, end quote. I will note, though, that I believe that USCIS is funded by application fees. Anyway, if this was a mandamus action, it also definitely had a claim for unreasonable delay under the Administrative Procedures Act, which would make it a pretty standard complaint in that regard. And that is because we know that Mr. Soni also argued that the A.P.A. permits review of agency inaction. The Seventh Circuit agreed, unless the court reasoned that the statute itself precludes review. Statute trumps the A.P.A., reasoned the court. Also citing to Patel, which strikes again, as it so often loves to do these days. The Seventh Circuit sympathized with Mr. Soni, recognizing that in the past year, adjudication of I-601A waiver applications has fallen 50%, and that the delay has ballooned to 43 months since 2017. But the Seventh Circuit believes that it's not a problem that it can properly solve. I'm positive other circuits will be deciding this case soon. Interesting final sentence, though, too. Quote, if the agency were to order Mr. Soni removed from the United States while his waiver application remains pending, that decision would be reviewable under INA Section 242A1. But this possibility does not allow judicial intervention in the absence of a removal order, end quote. Interesting, though. Wonder what that means. Can you challenge an I-601A delay through the petition for review process? I don't know how that would really work, but also, here's that sentence to remember. Didn't help Mr. Soni, though. And that is Soni v. Jaddou. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. We all know the immense dedication it takes to be an immigration lawyer. You fight tirelessly for your clients, their families, and their futures, but let's face it, the administrative side of running a practice can feel overwhelming. Mountains of paperwork, endless calls, juggling deadlines, it can easily steal your focus and leave you feeling burnt out. But what if there was a way to simplify all of it? I want to tell you about FileVine, a legal case management platform specifically designed by lawyers for lawyers. FileVine keeps all case information centralized in one place. Plus, FileVine's immigration-specific tool, Immigration AI, uses the most advanced AI-powered technology to extract vital information from passports, birth certificates, and other essential documents, and automates USCIS form filling through smart questionnaires available in up to 170 languages. Pretty impressive. FileVine and Immigration AI can give you back precious time and energy, allowing you to focus on what matters most, your clients and their cases. So if you're ready to reclaim your time and rediscover the joy of practicing immigration law, head on over to immigration.ai/immigration review. Links in the show notes. Our final case is A.P.A. v. U.S. Attorney General, published by the 11th Circuit on June 6, 2024. This case is about timely asylum filings and transgender withholding of removal claims, with just a lovely little coincidental case title pun for us immigration litigators. Miss A.P.A., an acronym of course, is a transgender woman from Mexico. She was sexually abused by an uncle as a child and entered the United States at about 10 years old. She qualified for DACA, and I guess she got it, but she lost that status when, in her 20s, she was convicted of a DUI. She later was arrested for another DUI and for possessing a controlled substance. The government decided to detain Miss A.P.A. during the last administration, and she was found removable for having entered the United States without authorization at 10 years old. She applied for asylum, withholding of removal, and protection under the Convention Against Torture, quote, based on the physical and sexual abuse Miss A.P.A. suffered as a child at the hands of an uncle, and claims of fear of future persecution and torture in Mexico as a transgender woman, end quote. And IJ denied asylum as time-barred and denied asylum again, and everything else on the merits. The BIA affirmed, citing to various now vacated precedents. Indeed, in a rare holding, the BIA noted that asylum is discretionary and held that, quote, Miss A.P.A.'s convictions for driving under the influence and arrests for marijuana possession did not merit a favorable exercise of discretion for asylum, end quote. The 11th Circuit affirmed the denials. The court first held that it didn't even have jurisdiction to review the denial of asylum as time-barred. Asylum applications must be filed within 1 year of entering the United States, of course, and Miss A.P.A. filed hers 17 years later. She was a child during some of it, and extraordinary circumstances can toll a late filing. But an IJ and the BIA didn't see them here, nor did they see changed country conditions, which can also excuse a late filing. This, despite Miss A.P.A. not realizing that she was transgender until 2019. But again, here, the 11th Circuit held for its part that the INA bars it from reviewing the question at all. That's mainly what this case is about. INA Section 208A3 reads that, quote, no court shall have jurisdiction to review any determination of the Attorney General under paragraph 2, end quote. And well, the changed country condition and extraordinary circumstance exceptions to the 1 year bar are contained at INA Section 208A2, subparagraph D, to be specific. But this issue is reviewable in other circuits, I believe, and that's because of INA Section 242A2D, the all-important savings clause implemented by the Real ID Act in 2005. Notwithstanding any provision of the INA, the circuits always have jurisdiction to review questions of law and constitutional claims under the savings clause. And not only that, the Supreme Court just told us in Wilkinson that questions of law include mixed questions of law and fact. That was essentially Miss A.P.A.'s argument. But before Guerrero, Asprilla, and Wilkinson, which really made these arguments powerful, the 11th Circuit had already answered this question, and had held that it's not reviewable. That is, an IJ and the BIA's refusal to extend the 1 year asylum filing deadline. That makes this case back to being about the prior precedent rule in the 11th Circuit, which has been a bit of a theme in the 11th Circuit of late. Quote, for a later Supreme Court opinion to abrogate a prior panel's holding, the later Supreme Court decision must demolish and eviscerate each of its fundamental props. End quote. And yes, the law has changed, recognized the court. Heck, as the 11th Circuit recognized in Ruiz, episode 160, whether the VAWA cancellation extreme cruelty, quote, unconditional requirement requires proof of physical abuse is a quintessential question of law that falls in the bucket of reviewability because it goes to the meaning of a statutory mandate, end quote. So too, whether undisputed facts satisfy a legal standard is now a legal question that the circuits can review, explained the 11th Circuit. As is whether an applicant has been convicted of a particularly serious crime, given, for example, the legal standard articulated in matter of NAM. That's KY v. U.S. Attorney General, episode 120. And of course, Wilkinson itself, from this term out of the Supreme Court, demands circuit review of undisputed facts to the exceptional and extremely unusual hardship standard, episode 204. But still, this panel believes that its prior precedent, Chacon-Botero v. U.S. Attorney General, which had barred review of this whole one-year deadline issue, still stands. Even if the facts are not in dispute, and even though, at least as to changed country conditions, there's definitely a clear legal standard, right? We talk about that on the podcast all the time, albeit usually in the motion to reopen context. But for starters, explained the 11th Circuit, quote, Congress tied the existence of changed circumstances to the satisfaction of the Attorney General. With those words, Congress made the Attorney General the only person able to decide whether the prerequisite has been met, end quote. And of course, the Attorney General is now an IJ or the BIA. And that means it's really discretionary, explained the panel. This is not the first time that the 11th Circuit has used this logic of late, and to me at least, I haven't seen this logic in another circuit. Really setting ourselves up to keep deferring to the BIA and Attorney General in the immigration context, even if Chevron gets vacated this term. No? Anyway, essentially for this reason, whether the IJ and the BIA properly refused to consider Ms. A.P.A.'s untimely asylum application won't be reviewed. On to the merits of withholding of removal then. The 11th Circuit didn't see a pattern or practice of persecution against transgender women in Mexico, which seems to be primarily what Ms. A.P.A. was arguing, at least before the 11th Circuit. Quote, establishing a pattern or practice of persecution is a demanding standard. Mistreatment of similarly situated persons must be extreme and pervasive, end quote. Still, that's a standard, and pattern or practice cases are hard to come by. By the way, if I'm not mistaken, I believe a couple of years ago the 10th Circuit held that there is a pattern or practice of persecution against transgender women in Honduras. Alright, fine, I looked. It's Gonzalez-Aguilar v. Garland, episode 101. Anyway, the BIA apparently considered both the problematic but also decent treatment of transgender individuals in Mexico, and didn't find the standard met here, that is the extreme and pervasive standard. Nor did the BIA improperly conflate, quote, the broader LGBTI community, end quote, with transgender individuals in its analysis. But if it had... The 9th Circuit appears to have a favorable transgender woman case of its own from Mexico from 2015, Avendano Hernandez v. Lynch, but the 11th Circuit held it's distinguishable. First, Ms. Avendano Hernandez had lived in Mexico as a transgender woman and been persecuted. Not the case here. And of course, country conditions can change, and Avendano Hernandez was 9 years ago. The 11th Circuit reads more recent Mexico Department of State reports as more favorable for transgender individuals, albeit imperfect. Summarily dismissing the cat challenge, the 11th Circuit affirmed the agency. And that is A.P.A. v. U.S. Attorney General. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/immigration review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.